We regularly host legal experts to help answer your questions. Today, Leanne Cusack's guest is a specialist in family law. Leanne.
Ask any lawyer, including a divorce lawyer, and they will tell you that family law is ultimately the messiest and potentially ugliest aspect of the law. And Tanya, you would agree.
Oh, absolutely.
Now, Noah Baumbach's The Marriage Story, or A Marriage Story, which is really a story about divorce, really made waves at the Oscars. Laura Dern won for her portrayal as a divorce lawyer.
It amounts to an ambush.
Withholding, Jay? Really? Alienating? All right. Well, those are fighting words, and it's simply false and does nothing to further this settlement.
The story is described, or divorce is described, as really death without a body, because it is so painful and so emotional for so many people. What do you see in your practice?
Oh, it's absolutely emotional, not so much, Leanne, when it comes to the people's possessions. That aspect is less emotional, I would say. But when you're dealing with custody and access issues, when you're dealing with children, essentially part of your heart is being ripped out. And spousal support is one of the most contentious topics as well.
Which is why you chose to discuss that today. So let's offer a little bit of a history of spousal support. I guess things were very inequitable for a very long time for these laws to have been put into place. What is the history of spousal support?
So some kind of concept of spousal support existed in the Canadian legislation ever since Canada was essentially established. However, the laws were very different and not equitable, not favorable towards women. And at that time, I would say prior to the 1960s, it would be only women who would be seeking spousal support for one simple reason that men always worked. They were the main breadwinners. Women stayed at home, cooked and cleaned, and raised the husband's children.
There must have been a precedent-setting case that really turned things around.
Yes. So in 1985, the concept of divorce was included, the concept of spousal support was included in the Divorce Act. And things were changed by the case of the Supreme Court of Canada, Moog versus Moog. In the 1990s, we started dealing with the concepts of compensatory support, non-compensatory support. Prior to that, it was based on fault. So essentially, prior to the 1960s, a woman had to prove that the husband was somehow at fault. So either he committed adultery or he was really cruel, and if the woman chose to leave due to the cruelty, then she was not eligible to claim spousal support. So even if she was thinking I have grounds, it was very difficult at the time for the woman to retain a lawyer because women were not in the workforce. Legal fees, even back then, were fairly expensive. So how do you take your husband to court when you cannot really pay your legal fees? So only a minority of cases were successful. So then when Moog came around, we started looking at concepts of forget about fault. A woman should be compensated if she made sacrifices, for example, of her career to advance her husband's career. Military wives, for example, come to mind. They travel a lot following their husbands, raise the family's children. And then, of course, after many years, it's very difficult to get back into the workforce. And in that situation, they could be left on the street. So that's what the woman would be compensated for. And non-compensatory element would be on needs-based. So if the woman needs support, the longer the relationship, the more spousal support would be owed in terms of the duration. Then we look at the number of children, who the children are going to reside with. And at that point, with that case, we started looking at some more defined concepts instead of something that is completely unfair, such as the husband's fault. However, there was still no formula. So essentially, the amount and the duration of spousal support was at the judge's discretion. The decisions were all over the place. They were fairly random until spousal support advisory guidelines released by the Department of Justice came into play. So since 2005, when spousal support advisory guidelines came into play, this is when a lot of case law started establishing precedents, and the cases gave us some clarity as to what the formula is. So in the formula, there's a low range, there is a high range, and there is mid-range of spousal support. Normally, judges go with mid-range.
We will cover that when we come back. Interesting, 2005 is the year you graduated from law school, as I understand it. So there's a coincidence there, but I do have to share with viewers in the commercial break. I asked Tanya if you were married or ever married, because you are a divorce lawyer or a family lawyer, and you said
that basically my prenup would be 100 pages. Who would sign that?
So I guess you've seen so much in the course of your career, it's given you cold feet?
Absolutely, yes. Correct.
Well, apparently the Canadian stats are 38% of Canadian marriages end in divorce. You think in Ontario it may be a little bit higher than that. When we come back, we'll chat more about the concept of spousal support, and this was a little bit of a legal lesson.